The UN document I'm going to look at today is this one here. It's a General Assembly document. It was distributed November 20th, 2023. We're still in the 78th session, relates to Agenda Item 79, and it's titled The Report of the International Law Commission on the Work of its 73rd and 74th Sessions. And it's actually the report of the Sixth Committee. And in this report, they talk about the two draft resolutions that were submitted at this meeting. The first one is L12, second one L21. This L12, it has to do with the report of the International Law Commission on the work of its 74th session, and it was adopted without a vote. Adopted without a vote. And then the L21 has to do with a draft resolution entitled Peremptory Norms of General International Law, and this one was also adopted without a vote. All right, before we get into the draft resolutions, let's take a look at the UN entities involved here. Well, first we have this was the document of the day was from the General Assembly, and it had to do with agenda item 79. So let's take a look at the agenda item 79. And this one is indeed the report of the International Law Commission on the work of its 73rd and 74th sessions. That is in line with the title here. And let's also take a look at the allocation of agenda items. This is where the General Assembly then allocates the items on its agenda to the various committees. And if we look here, item 79, it goes over to, indeed, it goes to the sixth committee. Here are the allocation of items to the sixth committee, and there's number 79 there. And now let's take a look at a sixth committee document, which it looks like it's titled Allocation of Agenda Items. So this is where the sixth committee accepts or acknowledges the items that are on its agenda. And here we go, and there is item 79 right there. All right, what is the sixth committee? As we know, it's one of the main committees. Here's the website of the General Assembly, and here's the tab for the main committees. And we know there's the first, second, third, fourth, fifth, and sixth committee. The sixth committee handles legal issues. And here is the sixth committee webpage, and they describe themselves as the primary forum for the consideration of legal questions in the General Assembly. All of the UN member states are entitled to representation on the sixth committee as one of the main committees of the General Assembly. And let's look at the UN Charter, and we'll look at the principal organs of the United Nations. And we know that the General Assembly is a principal organ, and subsidiary organs may be found necessary and may be established in accordance with the present charter. Let's look at the chart. Here we are, the principal organs of the General Assembly, and listed under the subsidiary organs is the main committees, and we know the sixth committee is under the main committee. All right, and for further legitimacy, let's go to the rules of procedure of the General Assembly. And if we go down to Rule 93, 96, we have establishment of committees. The General Assembly may establish such committees as it deems necessary. And then we have Rule 98, and it talks about the main committees of the General Assembly. And they are as follows, and it's the first, fourth, second, third, fifth, and sixth. And there's our legal committee there, the sixth committee. All right, so what is this International Law Commission? Actually, it is a subsidiary organ of the UN, as we see here. It's a subsidiary organ of the General Assembly. Here it is right here, the International Law Commission. And how did it come about? I checked the charter. It's not in the charter, but here we see a 1947 report from the Progressive Development of International Law and its Codification. It actually started here. It says that this committee was established by the resolution of the General Assembly in 1946, held its first meeting in 1947, and it adopted its own agenda. And then finally, in paragraph 3, it says right here that that the committee agreed that the effect could best be given blah, 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 by the establishment of a commission composed of persons of recognized competence in international law, and this commission would be called the International Law Commission. And that's how it came about, its birth from this 1947 report from the Progressive Development of International Law and its Codification. All right, let's get to the first draft resolution, and that's L12, and it's entitled Report of the International Law Commission on the Work of its 74th Session. And here's L12 itself. It's a 7-page draft resolution, and it refers back to if we look here at the very first operative paragraph, it takes note of the report of the International Law Commission on the work of its 74th session. Here is that report right here, 132 pages. And the report itself is quite extensive and touches upon many, many subjects. Um, in fact, the draft resolution seems to just basically take note of the report, puts it in the record, and then seems like there's a bunch of follow-ups, different meetings on different subjects. Like for instance, here it is talking about draws the attention of governments, in particular on all the specific issues identified in Chapter 3 of the report regarding prevention and repression of piracy and armed robbery at sea, subsidiary means for the determination of rules of international law, sea level rise in relation to international law. So it looks like the United Nations actually it does recognize that sea level rise is either happening or will happen, and it could affect matters in international law. So they're working on that now. And there's lots of other subjects as well. Diversity of legal systems of member states, multilingualism. It recalls that the seat of the International Law Commission is at the United Nations office at Geneva. So it does quite a bit here, and if we go back to the document itself, we do see that the committee adopted the draft resolution without a vote. All right, we're going to watch a little bit of the sixth committee discuss that L12 draft resolution.
I draw your attention first to the draft resolution contained in document A/C6/78/L12, entitled Report of the International Law Commission on the Work of its 74th Session. The draft resolution was issued earlier this week and is available online. I will invite Ms. Lucia Solano of Colombia to introduce draft resolution A/C6/78/L12 on behalf of the Bureau.
English.
In preambular paragraph 11, the General Assembly would note the establishment of a trust fund for assistance to special rapporteurs of the International Law Commission or chairs of its study groups and matters ancillary thereto. By operative paragraph 2, the Assembly would express its appreciation to the Commission for the work accomplished at its 74th session, and note in particular the completion of the first reading of the draft conclusions on general principles of law and the commentaries thereto, while operative paragraph 5 would draw the attention of governments to the importance for the Commission of having their comments and observations by 1st December 2024 on the draft conclusions on general principles of law. Operative paragraph 6 would draw the attention of governments to the importance the Commission attaches to receiving their comments and observations on the topic immunity of state officials from foreign criminal jurisdiction ahead of its second reading.
Okay, and so she basically just continues on, and she um, just restates a few of these paragraphs at random, and then after that, they go back to the chair, who then calls for the vote.
The committee will now proceed to take action on draft resolution entitled Report of the International Law Commission on the work of its 74th session. Is there any delegation wishing to explain its position before action on the draft resolution? I see none. May I take it that it is the wish of the Sixth Committee to adopt draft resolution A/C6/78/L12 as revised without a vote? I see no objection. It is so decided.
All right, now let's take a look at the second of the two draft resolutions in this report. The second one is a draft resolution entitled Peremptory Norms of General International Law, the Latin phrase Jus cogens. And if we go to the draft resolution, we see here that they're considering Chapter 4 of the report of the International Law Commission on the work of its 73rd session. Let's take a look at that. All right, here's that report of the International Law Commission 73rd session. And if we go down to Chapter 4, we see here that this is the peremptory norms of general international law, Chapter 4. And then if we look at conclusion 3 of this report, it defines peremptory norm of general international law to be a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. So basically, this is something, a law, or just a practice that all human beings agree on, or almost all, or at least a consensus of every state or almost every state of something that we should or should not do. And then here they give you some examples. And so this is a non-exhaustive list. And there's some examples here. Prohibition of aggression, which I believe in this context is probably the invasion of one state into another. Prohibition of genocide, crimes against humanity, basic rules of international humanitarian law, prohibition of racial discrimination and apartheid, prohibition of slavery, prohibition of torture, and the right of self-determination. That is, each state can make its own laws and rules about what it wants to do. Of course, that's not absolute, but so these, as you can see, are basically, these are no-brainers. This is what everybody would probably agree to, that this is something that should not be done. And so, what's the legal consequences of this? Well, that can be found in conclusion 10, and there's two paragraphs here. The first one that talks about if the treaty is void if at the time of its conclusion it conflicts with a peremptory norm of general international law, but it'd have to be something that exists at that time, at the time that the treaty was concluded. If there was an existing peremptory norm of general international law, then that treaty itself, it has no legal force. So if, for example, there was a treaty that talks about international slavery and the regulation of it, then that treaty would have no legal force whatsoever. And then the second instance of where this might be seen is if a new peremptory norm of general international law emerges, and then any existing treaty which is in conflict with that norm then becomes void and terminates. And all the parties to that treaty are released from any obligation further to perform the treaty.
I thank Mr. Koshet for his introduction of the draft resolution and for his coordinating efforts over the last year. The committee will now proceed to take action on draft resolution A/C6/78/L21 entitled Peremptory Norms of General International Law. I thank Mr. Koshet for his introduction of the draft resolution and for his coordinating efforts over the last year. The committee will now proceed to take action on draft resolution A/C6/78/L21 entitled Peremptory Norms of General International Law, use cogens. Is there any delegation wishing to explain its position before action on the draft resolution? I see none. May I take it that it is the wish of the Sixth Committee to adopt draft resolution A/C6/78/L21 without a vote? I see no objection. It is so decided.
So the Sixth Committee there adopted the draft resolution without a vote. Finally, after the vote, the chair asked if any countries wanted to speak in explanation of their position after the adoption. And you have a bunch of states that did. Here's one, for example, Lebanon did speak on behalf of these countries, about 10 or 12 of them. And then you also China, Argentina, Singapore, all these other countries did speak, explaining their position, but only after the adoption. All right, and we're going to listen to Lebanon. They decided to speak in explanation of their position after the adoption of the draft resolution, and they spoke on behalf of these countries. And even though it was adopted, they are just putting on the record what appears to be an objection or criticism of the Sixth Committee. Lebanon's objection or criticism seems to stem from the fact that the International Law Commission made certain recommendations to the committee so that the committee would then adopt those into the resolution for the General Assembly to adopt. However, the Sixth Committee decided not to encompass all of those recommendations into the draft resolution. And so let's listen to him speak now.
Not recalling the main tenets of the ILC recommendation will risk undermining the institutional relationship between the Commission and this committee. In this instance, the Commission recommended the General Assembly to 1. Take note of the draft conclusions. 2. Annex the draft conclusions to the resolution. 3. Ensure their widest dissemination. And 4. Commend the draft conclusions and annex, together with the commentaries thereto, to the attention of states and to all who may be called upon to identify peremptory norms of general international law and to apply their legal consequences. None of these recommendations imply an endorsement of their content. They simply aim at making states and other relevant stakeholders aware of the conclusions, and it would be their prerogative to evaluate, use, or even disregard them as they deem fit. Even so, the resolution we have just adopted only encompassed one aspect of this recommendation, in a departure from the general practice of the committee towards the ILC products. Madam Chair, despite positions on a myriad of topics of ILC outcomes over the years, this committee has always managed to keep the practice of taking note, disseminating widely, annexing and commending a wide array of ILC products. And this is so because the premise has always been the same. These actions are done without prejudice to states' views on the matter and do not prejudge any collective decision of member states as to whether and how the outcome of that work will be used in the future.